in case number 240864, City of San Antonio versus Realme.
May it please the court, Ms. Stroh will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
May it please the court. My name is Jackie Stroh and I represent the City of San Antonio. The primary question for this court's decision today is whether Nadine Realme was engaged in an activity associated with enjoying nature or the outdoors when she participated in a 5K turkey trot, the route of which traversed a city park and hugged the natural feature of the City of San Antonio, the San Antonio River. The answer to that question is yes. Secondarily, the city has asked the court to determine that no evidence exists of gross negligence, which is the standard under the Recreational Use Statute, under either the objective or subjective prong, entitling the city to a rendition of judgment in its favor. Turning first to the application of the Recreational Use Statute, there is no dispute that the city owned the property in question and that it qualifies as a governmental unit as that term is defined under the statute. There's also no question that Realme did not have to pay the city to use the property, and the city did not have to invite her or expressly permit her to use the property for the statute to apply. So the only question is whether her activity constituted recreation, as that term is defined under 75.0013. So, of course, when construing a statute, the court starts with the text in the plain language, and turning to that language, there are several important hints that indicate that the language is to be construed broadly and not strictly. First, if you look at 75.0013 itself and the way it starts, it says recreation means an activity, quote, such as. So from the very get-go, the statute indicates that it's meant to be non-exclusive. Then when you turn to the catch-all provision itself, it begins any other activity. And as the state of Texas noted in their amicus brief, this court has held that the phrase any other denotes a broad connotation. So it begins.
So under your interpretation, would any activities be excluded?
Sure. This court has already held, for example, spectating at competitive sporting events. There have been. So we have said no, not all walking would qualify. We have limited it to outdoor exercise.
Well, if I'm walking to work outdoors and getting exercise on the way,
and I would think
maybe I don't like it, but that's the way that I have to get to work because my car's broken down.
Right. And of course, you don't look to intent. It's an objective standard under this court's precedent. But I would suggest a couple of sort of tests to determine whether an activity falls within the Recreational Use Statute that would help you answer a question like that versus a situation like this. So instead of looking to whether enjoying nature or the outdoors is integral to the activity, as the plurality said in Williams, or closely associated with it, as Justice Guzman said in her concurrence in Williams, I would suggest that the court look and see whether enjoying nature or the outdoors is incidental to the activity. So, for example, if you're walking to work, if you're sitting at a bus stop outdoors waiting for a bus, is that activity incidental, or is enjoying nature or the outdoors incidental to that activity?
And if it is, you would say it qualifies?
I would say it does not qualify.
So it doesn't qualify if it's incidental, but it does qualify if it's integral or closely associated?
Well, I say less than integral or closely associated.
So what would you say it does qualify? Non-incidental?
Non-incidental?
What does that mean?
I think
if
the court's
I'm driving on the way to work and I go through Zilker Park on the road and I've had my windows rolled down because it's a nice day, is that incidental?
Pleasure driving is expressly included in the statute.
Off-road pleasure driving is. It seems to be pleasure driving.
It says pleasure driving, including
motorcycling and off-road automobile driving and the use of off-highway vehicles. Your position is that any driving is included?
Well, I'd say pleasure driving is.
But you just said it's an objective test, not a subjective test. What's pleasure driving?
Well, I think it's objective in the sense that you look at what the person is doing and facts related to that. So it's not, is this activity associated with enjoying nature at the outdoors? Do I enjoy this activity under the catch-all provision? But you have to look at facts. Just like you have to look at facts in this case. You have to look at the fact that they were outdoors.
So everybody commuting and walking to work is going to be covered.
No, because that's not necessarily pleasure driving. I mean, pleasure driving means, I think, something for satisfaction and enjoyment, not a necessity of daily life, which commuting would be. I mean, I think you have to look at facts.
If I'm taking my son to a sports game, it's pleasure driving, but if I'm going to work, it's not.
Well, I don't want to get too caught up on the pleasure driving because that's not really why we're talking about the catch-all provision and not the pleasure driving provision.
Well, pleasure seems to be connected. I mean, maybe that is enjoying nature or the outdoors is what they're talking about when they insert the word pleasure there. That would make sense.
I mean, it could be.
If you have a convertible or something.
You could, if you have a convertible and you're enjoying the sunshine or whatever it is, yes, that could be.
What if we went along with you as far as that being incidental? I think that one reason, and certainly it's arguable, that the reason that people engage in this type of activity, these type of races, is for health. I mean, maybe not enjoyment so much. They're just doing it because they want to be healthy. So what would that do to it?
But again, you're looking at the reason this individual person is engaging in the race, and that the court has
I'm
said.
saying from an objective point of view.
So
Objectively.
So I would go back to the court's opinion in Torres. So the court in Torres said that swinging constitutes recreation under the statute, and even though it was the prior version, the court said it would also apply under 3L, the new catch-all provision. But if you go back and you look at the briefs and you look at the oral argument transcript, the person was sitting on the swing because there were ants in the bleachers and she didn't want to sit in the bleachers to watch the softball game. So she went to sit on the swing to watch the softball game. That didn't enter into the court's analysis at all under the catch-all provision. What the court said is swinging objectively an activity that can be associated with enjoying nature or the outdoors? And the answer is yes.
So in this case, suppose that we have the same woman running the exact same step for step, but it was because her job was as a courier, and someone said, I need you to take this as fast as you possibly can, this is a life-saving, whatever. And so she goes out, she sort of dodges around the slopey part of that. Your answer is it's recreation?
My answer is that would be one factor to consider in determining whether it is recreation or not. My personal viewpoint would be that it is not. And you can look to, for example, the state of Texas cited in their amicus brief, a case that makes a distinction between activities done professionally and activities done in an amateur fashion, and that activities that are done in an amateur fashion lend themselves much more to a definition of recreation than activities done in a professional standard.
But that means, though, that we can't just look at the activity necessarily. So your swing example is, well, swinging is something that is recreational, so we don't even need to find out why. And if that really were the end of it, then we'd say, well, this person literally ran the exact same route, the exact same time, wearing the exact same clothes, whatever. But we can't end there. We have to know more about why she did it.
Well, I guess my answer is it's nuanced. It has to be, because you don't have a unifying factor in all of the different activities that are listed in the Recreational Use Statute, and you're not going to. So you've got to look at things like, was the activity outside? Was the activity involved with a park or other, features of nature? Is this an activity that can be done for purposes of enjoying nature or the outdoors? I mean, all of those factors come into play. The court's not going to be able to look at one particular thing. And I would also note that the Recreational Use Statute itself, the terms of the Recreational Use Statute itself, definitely justify treating similar activities differently. So, for example, with respect to governmental units, you don't have to pay the government to come onto the property, but you do have to pay private parties. So it can be the exact same activity, but the government is protected and a private person wouldn't be. So it's totally appropriate to have a nuanced view, look at the factors, and treat even the same underlying activity differently by looking at those factors and then ultimately deciding, not essential. There's nothing in the statute that says enjoying nature or the outdoors has to be the exclusive.
Could we make the textual hook that the argument that you're making here, but tell me if this might follow some interpretive principle. 75.013 says recreation means an activity such as, and then this long list. ordinarily, if the legislature wants to say, sky blue, and then it says sky blue for purposes of this chapter is defined as pink, then you got to take that as it comes. But here, where there's not really anything on the enumerated list that doesn't seem like recreation, we also should still be thinking about what it means to be recreation, correct?
And I just want to make sure I'm clear, Justice Sullivan. Are you referring to the construction canon that if one thing is listed, the legislature meant to exclude other things as a general principle, and would that?
No. There's clearly no expressing this from here that says it says such as.
That's right.
If this enumerated list said recreation shall mean an activity such as, and the ledge amended it to Justice Busby's hypothetical, and it said shall include, trudging to work at a job you hate, then you'd be like, okay, well then they've said that the sky is pink instead of blue, and we have to take that. But where everything on here is like, oh yeah, that looks like it could be fun. That could be a recreational activity, rock climbing and frisbee golfing. We should still take some content from the fact that it's recreation that is being defined. Is that right?
Sure. And you're talking about maybe like use some generis or nociter associates, those kind of construction canons where you're talking about defining the catch-all provision or the term recreation by the different expressly listed activities.
Yeah.
I mean, I think that's perfect. I know those two doctrines are meant as limiting doctrines, but I think they help the city here. So, for example, and I'll give the court some examples. So, activities that have similarities to the activity here: exercise, swimming, hiking, water skiing, bicycling, mountain biking, dog walking, rock climbing. I mean, the state of Texas noted in their amicus brief that jogging forms the trifecta of a triathlon, along with two activities that are expressly mentioned in 003, swimming and bicycling.
But if you're jogging to work, because not in this building, but some buildings happen to have a gym where you can shower at work, then that's not covered.
Well, I mean, think about it, Justice Busby. Are you doing
Right.
I mean, objectively, when you are walking to work, you are sitting at a bus stop outside waiting to catch a bus to go to work, those kind of things. Objectively speaking, do people do those to enjoy nature or the outdoors, or do they do them out of necessity to get from point A to point B, to get to work? I mean, the 5K is optional. You don't have to sorry.
It was for her. What do we do with the kind of class of people who join these races, but this is their livelihood? They have sponsorships. They travel around doing this. How do you approach that? I mean, I recognize we're talking about a very few people, but what do we do there when they love running, and so it is recreational to them, but they are also professionals?
And I'm sure I'm frustrating the court because I don't have a perfect answer for the court on all of these questions, because it's going to be a nuanced inquiry and it's going to be a fact-specific inquiry in almost every case.
So what's the analysis?
Right. And so what I was suggesting to Justice Young is that you use sort of factors. And one of the factors would be, well, this is a profession, a professional activity as opposed to an amateur activity. So when it's an amateur activity, it's much more likely to be recreational than a professional activity. Then you would factor in all the other things. Is it outdoors? Do you have natural features? All that kind of things. And that one tick may be enough to say that doesn't qualify as recreation, whereas amateur participation by choice, that may be another factor.
So would professional mountain biking, if you're in competition for mountain biking, you would say that's not covered?
That's different, because here in this case, you're dealing with the catch-all, and so you have to satisfy the catch-all language, which says an activity associated with enjoying nature or the outdoors. That's not mountain biking, because mountain biking is expressly included in the statute.
And what do we do with the fact that the legislature added on-leash and off-leash walking of dogs after any other activity associated with enjoying nature or the outdoors was in the statute? That seems to suggest to me that dog walking is not what they had in mind by another activity associated with enjoying nature or the outdoors.
I don't think it suggests that at all. I think it suggests that the legislature was trying to make express, or certainly could suggest, that the legislature was trying to make express something that was already implicit, so that under judicial interpretation, that activity would not be excluded by some court decision. I mean, there's nothing to suggest that wasn't intended to be part of the statute. or the catch-all provision any more than the alternative that I'm suggesting, which is it was always intended to be part of it, and the legislature just made express. And plus the fact, at least now, it certainly can be considered under a use generis. I mean, it doesn't have to come before. This court's precedents say surrounding the general phrase. And so that certainly can be considered today in interpreting the meaning of the catch-all provision.
So maybe the answer is no, but I guess I'm wondering, is it possible to distill the test for the catch-all provision down to sort of like a single sentence? I mean, what would be your best crack at that? Like, an activity falls within the catch-all provision if blank. What is the blank?
I think it's virtually impossible, but my best crack at it would be to say, along the lines of what I said today, is enjoying nature or the outdoors incidental to the activity when looking at the various factors associated with the activity. I mean, that's my best shot.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Keto will present argument for the respondent.
Mr. Chief Justice, Your Honors, may it please the court. I'd like to say at the outset that it's clear from the first 15 minutes that this particular fact pattern opens itself up to some very entertaining hypotheticals. So if I may, give a quick roadmap of what I'd like to articulate before attempting to field them. The brief that was written in this case by my co-counsel asked this court to essentially adopt the Fourth Court of Appeals opinion and use the Williams plurality, have that become the holding of the court, and say that essentially one thing that all of these categories have in common is they don't involve competitors. And that is certainly an option. I'd like to discuss two others. One is the rule that Justice Boyd proposed in his concurring opinion. And just in the past 15 minutes, you've heard my opposing counsel say trying to find a categorization for all of these different types of activities. She used the word impossible, and I don't disagree. And what Justice Boyd's point in his concurring opinion was, when you have a statute that can't be interpreted fairly, and the statute deprives an individual of a common law right, you don't apply it unless you can do so in a strict construction. In this particular case, it respectfully said you can't do so. But my third argument, and this suggests that maybe Justice Boyd might have missed one thing, and there is another route here that has something that all of these definitions of recreation have in common. And that is that none of the activities that are listed involve an activity where the property owner is expected to make the property safe for ordinary pedestrian transportation. I know that sounds a little bit wordy, but the fact is this statute has been around for 60 years, and it's been applied to the public since 1995. The catch-all, I believe, came in 2005. There is a reason that running and walking have never been on this list, and it's not because the legislature assumed that people didn't run and walk in parks until, just now. So we know that's not the case. We have to, talking about canons of statutory construction, avoid a construction that yields an absurd result. And I don't believe that it is possible to interpret a provision that uses the word enjoying without necessarily talking about the subjective intent of the person who is the plaintiff in that case. So as Justice Boyd said, some people enjoy mowing the lawn, some people don't.
What if it was not the subjective and the intent, and we have to figure out this person just really hates running, but they're actually masochists, they sign that for it, or something like that. But instead, to ask whether the activity is one that's done for its own sake, as opposed to instrumental. My career hypothetical, for example, obviously you're doing this in order to get from point A to point B. The getting to work examples, getting from point A to point B. But a race is done for its own sake. The expenditure of calories, the energy, that's recreation in the most normal sense of the word. Why wouldn't that be a way to solve the problem?
I'd say that the reason that I would caution against that interpretation is because I don't think it fits within the goal that the legislature is using when enacting the statute in the first place of saying, well, could a specific activity become recreation? I think that's the second question they were asking. When it was initially passed, it was done to encourage private landowners to open their land, so Boy Scouts could go camping on it, or local groups could play softball. And eventually, it was extended to the public, following a decision from this court in City of Dallas versus Martin, in which it said, no, the only remedy for premises liability against the state comes from 101.022 of the Tort Claims Act. So when this court speaks, the legislature listens. To your question, why would we not construe the catch-all provision to go to what the end goal is here? Why don't we construe the statute as a whole to say, is the plaintiff suing for something that would serve the purpose for which the statute was enacted? And if the answer is no, why are we discussing recreational use here?
Engaging in a fun run ordinary pedestrian transportation? I think that's the test that you were referring to.
I would say that because ordinary pedestrian transportation could include walking or running or jogging, whatever you call it, just depends on the speed. Whether you're walking with someone else.
So your point is that walking and running are just excluded. They could not ever be characterized as recreation because they're a form of locomotion, and that just is not what the legislature contemplated.
Yes, Your Honor. And certainly I think if this court reaches that holding, if there is a groundswell of support for immunizing landowners and public entities for races, it will happen. And I think the amicus briefs that were filed in support of my opponent's position in some way help mine. I mean, there's no case law on this, correct? In any jurisdiction in America. There's also no recreational use statute that covers walking or running. And yet turkey trots have been around since 1896. And fun runs continue to occur. And yet somehow no one's ever addressed this question of whether walking or running requires you to prove the status of the trespass.
Just out of curiosity, I've missed this in the brief. What's the source for it? Fun runs in 1896, turkey trots in 1896.
There's a footnote in the city, I believe it's either the state or the county's amicus brief. And as an aside, it happened to occur in Buffalo, New York, where I'm from, so I just know that as a real thing. Having said that, the point of excluding pedestrian transportation is essentially you can't parse it out. If two people are walking to work because they enjoy the nature or outdoors and they have the misfortune of admitting that in their petition, should that change the burden on the landowner as opposed to someone who walks to work that day because their car is broken down and it's raining and they really prefer not to be there? It just doesn't seem to make sense.
It seems that all along the lines of thinking that you're offering, that what this statute seems to be doing is protecting the city from having to make environments safe that it sort of can't reasonably be expected to make safe, but you don't want to discourage it from allowing people to use those environments because you want people to have recreational opportunities. And this sort of a run, we have this flood of people running down the street together, seems reasonably characterized as it's an unusual use of the environment, which the city, under normal circumstances, isn't expected to manage its streets and sidewalks in a way that accommodates a flood of people running down the street at the same time. But we don't want to prohibit it, so we're going to call it recreation and give them a higher liability threshold.
So, allow me to answer the question, sort of the question. If we look at pages 485 to 92 of the record, you see full color photos of the danger. My client would stick a piece of metal and used to hold a sign that is around grass that has clearly been freshly trimmed, The sign is gone, but a shard of metal is sticking up from the ground. The record reflects that the city of San Antonio maintains this daily. It looks at it weekly. Regardless of whether this is licensee or invitee status, we're talking about can we use circumstantial evidence to prove actual notice. That's the cause of the injuries, is things sticking up. Now, if somebody working at HEB's headquarters across the street doesn't want to wait in line for a cab and decides to walk across the street to sit on a corner and wait for an Uber but accidentally trips over the thing, he's not engaging in recreation, he's waiting for a cab. But if somebody who's walking along the sidewalk that the city has an obligation to maintain for pedestrians in the first place trips over the same thing that the other person was just crossing unintentionally to get an Uber, they have a different standard of proof. It simply makes no sense. The standard of maintaining places for ordinary pedestrian use has nothing to do with the recreational use.
It allows them to allow the fun run without worrying to an undue degree about whether this environment is safe for a crowd of people who are running and packed in together and not using the environment in the way that it's normally used.
I agree that is a sensible policy goal. And if I was in the legislature and was asked, should we protect our municipal parks for voluntary fun runs for charity? Encourage, yes. But the question isn't, is that a good idea? The question is, does this particular catch-all provision that requires us to talk about whether someone's enjoying it or not, should that be interpreted in a way that gives immunity to some people, immunity to the same entity for claimed by some people and not against the other people?
I wonder whether moving up from the definition to subsection C of the previous section, if an owner, lessee, or occupant of real property other than agricultural land gives permission to another to enter the premises for recreation, then they have different liability. That seems to be written from the perspective of the person giving permission. So if I give permission for you to enter my land for recreation, the question is, how am I sort of reasonably expecting my land to be used by you? It's not how do you subjectively intend to use my land. Is that wrong?
I believe your recitation is correct. The reason why I'm parsing out the difference between the points of the Recreational Use Statute that cover private property owners from public is the same definition, the same catch-all is going to cover both of them, right? But in 75002, the language is amended to say that nothing in the statute shall apply to claims against the government, essentially. But it claims that against the government, the property that is owned, operated, or maintained by the government. That includes every sidewalk and every street in the state is maintained or operated by a governmental entity. Literally, you can't leave your own private property without encountering property that is like that or fits within the definition. Absent using the air. So the point being, if we have a definition that construes what is on a sidewalk or immediately adjacent to a sidewalk, and we look at that and say, well, were they enjoying at the time? We just fall back into the same trap of that can't be the proper construction for a statute that was designed to encourage people to open their property or to encourage the state to allow its property to be used for that reason. Did that answer your question? Did I miss?
Well, I guess my question was, why would we think at all about the subjective purpose that the person has for using the property when the statute seems to be written in terms of the government's reason for giving them access to it, which should be judged sort of objectively from the government's perspective. Why is it offering people access to the property in this way? Well, in this case, it's a fun run, which is for the sort of recreational enjoyment of the people of San Antonio, and so there you go.
If I say that the answer to your question is because it itemizes several things, and then running and fun runs and walking aren't on there, and the only other way we can get there is to the catch-all provision, which uses the word enjoying. So we're stuck because it's not itemized.
Does the word recreation still matter because it's just defined as to include such as this list, and so we would still be concerned with what the word recreation means.
Yes, Your Honor. It matters to the extent of how should this court pick the rule of statutory construction that it wants to apply. And that, again, goes back to Justice Boyd's concurrence, is that it doesn't fit within any of them because it says such as, so it's not an exclusive list, and it has a catch-all that involves a word that would be absurd if it applied to every piece of property that the government maintains. So there has to be some other rule that applies as well. You can't use just the textbook definition of recreation because we have defined terms. Or a dictionary definition, excuse me. So if this court were to conclude that this statute is just simply too convoluted to apply in any way that doesn't require extensive litigation every single time someone is injured on public property as to what their intent was or whether they were enjoying it or, I use the other words, whether it's incidental to the activity, this court can very easily avoid all of those jurisprudential passages by saying, in this case, Ms. Realme may sue the government without the burdens imposed by the Recreational Use Statute. This doesn't seem to be something that's going to open the floodgates to frivolous legislation or frivolous litigation in the state by virtue of the fact that the question's never been answered or never been apparently posed to an appellate tribunal in the state.
It seems like you and the Chief Justice's question are a little bit on the same page in a way, because you opened by saying that the question is whether the property owner would be expected to make the property safe for the activity. And the Chief was pointing out that the statute focuses on the landowner's perspective. So how would we apply that here, right? That presumably the city is expected to make its streets and sidewalks safe, and they're going to have to do that for some people, at least, no matter how we construe this statute, because some people are walking to work or commuting to work. So the burden on them is going to be no different to maintain those to a reasonable standard, because at least some people aren't going to be protected. But if that's the case, then why should the standard be different for one person using it versus another, depending on whether, if you're running on the street because they've closed the street for a fun run, and you're running on the street and you fall in a manhole that's uncovered, versus you're driving a car to work and your tire goes in the hole. It seems like the state's going to be, or the city, whoever owns the roadway, is going to be expected to maintain that anyway. So I'm just not sure whether that perspective of the landowners, from the landowner's view, helps us much with answering the question. But maybe it does.
This is where I was going with proposing that definition, is that landowners, whether it's the government or a private owner, really can't be expected, practically speaking, to make the property safe for hunting or rock climbing.
If they're expected to make,
yeah. And so it defies expectation that we want to encourage people to have a place to go swimming, but we don't expect everybody that has a lake that opens it to the public to dredge a specific swimming channel and,
get rid of all the snakes.
Exactly, get rid of all the snakes that are in it. And the same thing would happen for, cave exploration or water skiing. We want to make them available, but they have inherent dangers that are with them, but we want to encourage the activity. The government can own all the property in the state, so if you allow it for that purpose, we're going to give you essentially an immunity where you have to prove gross negligence. But I can't fathom a reason why it would be necessary to add, without the legislature's command to do so, that people are immunized when every time a private property owner, they're immunized when they allow people to walk across their land, whether it's...
They already did it, if you do it with a dog, right?
Yes, right. Which, again, goes back to the question, does artful pleading ultimately determine your burden of proof? If someone was literally walking their dog when they tripped, would it be better for them to just not talk about the dog? At the end of the day, the danger is still the danger. And if the government has an obligation for maintaining the property, it shouldn't have the fortuitous windfall of, well, fortunately that person had a dog, now they have to prove the gross negligence, whereas non-dog walkers would have something else. If this court interprets the statute, interprets the catch-all to say it doesn't apply here, and that's the narrow holding of this court. If this catch-all doesn't apply, either because it can't be applied, and the rule from Satterfield versus Satterfield says abridging a common law right with an ambiguous statute or not applying it, Or alternatively, it says we're not applying it because we believe in our holding in Williams, and this list just generally doesn't apply to competitive sports.
What do we do with the list that's in 75.002E? In this section, recreation means, in addition to its meaning under 75.001, the following activities: hockey, rollerblading, soapbox derby use, and paintball use. Does that mean that those things would not be covered by the catch-all? Like, what do we do when we have, and you don't have to put it in Latin, but when we have like an enumerated list and then another enumerated list, what do we do with that?
It's an excellent question because what do we do with this statute seems to have been the question that has been asked by at least this court for the last 10 years. And to say that this is sort of a legislative boondoggle would be an understatement. Every legislative session, people with special interests come and ask the legislature to include more things in the recreational use statute, which is why we didn't stop with the catch-all provision, and pretty soon we had to add disc golf and dog walk. It's sort of absurd. But to answer your question very directly, 75.002 used to be very different. It used to carve out an exception for those specific municipal activities. And if you look at the legislative history of the changes that were made in 2005, when I realize I'm almost out of time. The statute used to say this section limits the ability of the state or a municipality or county only for damages arising directly from a recreational activity described in subsection E, which was the hockey. They then took that out, scratched out the subsection E part, and changed it to the current language, saying nothing in subsections B or C, which is the part referring to private landowners, they're notwithstanding those sections. If a person enters premises owned, operated, or maintained by a governmental unit and engages in recreation, the government unit does not owe a greater indemnity. So it was as if, or it appears as if, the legislature was trying to clearly state that this is going to supplement the Tort Claims Act without thinking about the fact that by removing the reference to the subsection talking about hockey, they left two lists, one of which applies only to the government and one of which applies apparently to everyone. I realize I'm out of time.
Any further questions?
I just want to make actually, I think this is from the theory you articulated us today, but to make sure that this, what I'm going to describe, is not recreational use. When I'm preparing for an oral argument, I like to take the law clerk that's assigned to it with me, and we take a walk around the Capitol grounds if the weather is nice. And we did that on Friday, talking about this case. I was not engaged in recreation at that time, under your theory, correct?
If you and your law clerk had been
just strolling around, looking at the beautiful trees and the lawn, the memorials, and talking about this case as we were doing.
And because you were looking at the trees and the lawn and the memorials, you missed the fact that there was a giant pothole in the sidewalk.
That did not happen this time, but it could. So when that happens, do I engage in recreation or not?
I don't know whether you're engaging in recreation, but you would not have a higher burden of proof under the recreational use statute.
That would not be something that 75.013L would describe. It would.
Correct.
Okay. And that doesn't strike you as just sort of an odd thing for a statute to describe recreation, because that sounds to me like literally the only reason to do that instead of sitting in our office is to be able to stretch our legs and to enjoy the beautiful fresh air, the beautiful environments.
Just briefly, yes, it sounds absurd. Of course it sounds absurd. We're trying to define recreation, which is a little bit of a fool's errand. But what we're really trying to do is give immunity to certain property owners. And should we be giving immunity to certain property owners when a member of this court and his clerk are taking a walk? Or is that the kind of thing where if you're injured, you should have to prove that you should have the...
Your argument is consistent. I got it. Good.
Let's see if that's a good thing. Thank you.
Mr. Kida. Ms. Stroh, you have 5 minutes.
So I'd like to know really briefly before I start talking about other points is that the position today, espoused by respondent, contradicts the position taken in their brief. The position taken in their brief is that if Nadine Realme had been running by herself, she would have been engaged in recreation under the Recreational Use Statute, and it was simply because she was participating in a 5K race that she was not engaged in recreation. So that is completely inconsistent with the position taken in their brief.
So that's not going to be fair, right?
Sorry?
some alternative theories, a new reason to reach the same result. Are you suggesting it's waived or something? Or?
I'm just saying it's new today. I haven't heard it.
You acknowledge that.
Yes. And it makes sense for them to say that her engagement in an individual activity, and it also makes sense to extend that to the 5K, that both of those would fall within the catch-all provision.
I wonder whether it's not the opposite, where the turkey trot is covered and the jogging isn't, because in the case of the jogging, the government isn't providing access to the sidewalk for recreation. It's just the sidewalk's just there and it's generally open for whatever uses people make of it. Whereas with the turkey trot, you're providing access to the city streets in this way, for the trot, for the race, for recreation.
And that certainly comports if the court's looking at the text and also to further the policy behind the statute. That interpretation would certainly make sense.
Do you agree that the jogging is not covered, just jogging down the sidewalk at 5 o'clock on a Tuesday?
No, I don't agree with that. I'm saying that it would make sense to consider the text and the policy to include the 5K here. But the way that the recreational use statute applies to governmental entities is they don't have to grant permission or an express invitation for people to come onto their property and engage in recreation. So a person who's running along the neighborhood, say someone is walking their dog and someone is running along beside them, or someone's walking the dog and they have a friend walking with them. I mean, I don't see why, as a category, that kind of activity would be excluded from the recreational use statute.
Because the legislature thought it should. But a lot of, like you said, a lot of these don't make sense. But maybe that's why they included on leash and off leash walking of dogs. Because if you're just walking on the sidewalk, even if you're doing it on a nice day and not on your way to work, that's not covered because the city is not making that available for recreation specifically.
But the city doesn't have to make it available for recreation specifically under the text of the statute. And I don't understand why, under the plain language of 3L, that would qualify. It says associated with, so connected or related to.
Because it renders a bunch of the rest of the statute a nullity. Why would you list hiking if walking is covered?
Because you can walk and jog and run for exercise outdoors without actually hiking up the side of a mountain. You can do that. You can.
That's exactly my point.
Well, I'm sorry, I must have misunderstood your question. But my explanation is it makes certain sense, it makes absolute sense to include that within the catch-all provision because hiking is something not categorically different, but slightly different to include expressly where maybe walking, jogging, and running would be included in the catch-all provision. So simply because you have hiking doesn't mean that walking, running, or jogging are excluded, and we talked about how that doctrine, the doctrine of including something specifically would not mean the exclusion of other things, especially when the statute is meant to be non-exclusive.
How important is the statutory term outdoor? How much work is that doing? So, imagine if, what you're doing in inclement weather, they move a portion of the turkey trot indoors at the last minute. I can imagine we could take two approaches there. Number one, turkey trots are recreational, and so the fact that it got moved indoors, we're still within the catch-all. Or we could say, well, that's not outdoors, so no catch-all provision. What do you think is the answer?
Right, and there's a case that's already addressed that. It is the City of Conroe versus Thomas case. The Beaumont Court of Appeals decided there they were having a day camp ball game, and it was intended to be played outside. It was moved inside due to inclement weather, and they said that still constituted recreation because of ball game.
Right, recreation. What your view is? Do you think that's right?
I think it could be right. I think it's one more factor that you're looking at when you're determining whether something constitutes recreation. So certainly if it's outdoors, that would be a plus in the column of recreation. If it's something that's usually done, 5Ks are almost exclusively run outdoors.
What about a track meet? If you've got a track meet on an inside track, and it's not professionals, it's just people doing it for fun. There's no nature, there's no outdoors, still covered.
And I would think that could be covered, and this would be another factor to consider. Does the person have a choice as to the location of the event in terms of participating? So say
if the city calls him, you can come or not.
No, if you're in a track meet and say you have an obligation, I don't know, say you're a professional runner or something like that, right? Yes, then I think that could definitely be covered under 3L.
Every time you say, well, here's another factor that you considered, you're pushing me a little further away from your position.
I apologize, Your Honor. I mean, I just want to, I guess my point is that it is a nuanced interpretation. If the court is looking for a one-size-fits-all holding that's going to once and for all explain 3L today, I mean, I don't think you're going to find it, and I think the prior oral arguments in Williams and Torres sort of explained that. I mean, these were the exact questions that were asked during those oral arguments. It's all these hypotheticals. I think the court, and I'm sorry I'm over, if I could just conclude with this one thought. I think the court can draw the holding as narrowly as it wants to today. So participating in 5K turkey trot on a national holiday on a route that traverses a city park and hugs the natural feature of the city of San Antonio. How is that not engaging in activity associated with enjoying nature or the outdoors? Doesn't have to say all outdoor exercising.
Or all rivers, all cities, right? Yeah. This was in Waco by that river, a different case, right?
We leave for another day whether a fun run is recreation.
Do you think there's anything I asked your friend on the other side whether or not doing activity that was for its own sake and not in service of some other objective end, that strikes me as still being objective, still seems to be connected to the idea of recreation, and it doesn't seem like it would create this hydra of factors that must be run.
That's true too. I mean, I did appreciate that test, the done for its own sake versus whether it's instrumental. Sure, that would work too, and I think here under that test, Realme's activity would clearly be recreational because it was done as part of a fun run. It was not done to get from point A to point B as you would be when you're walking to work.
Any further questions? Thank you, Mr. I think it's fair to say the statute itself is anything but recreational, and we appreciate both of you helping us deal with it. And the case is submitted. That's the last argument for today in the Marshall Adjournment Court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.